Many of you who have joined already know me, so I won't spend much time introducing myself. My name is Nirmala Gowda. I'm from Mapping Malnad. And this is our third series of Malnad Dialogue with Water Action Forum. And today we're going to talk about the dangerous rollback that has happened to Environmental Impact Assessment 2006 notification. And it's going to be structured in two parts. One is to understand how the exemption itself is taking place, and the second part is what are the consequences of the exemption. And I have with me Chaitanyan Devika Kulashekaran. He is a senior researcher with the Center for Financial Accountability, Delhi, and his presentation will be about waste to energy plants and what are the implications. So the image that you see here is of a landfill inside Shettihalli Wildlife Sanctuary. Shettihalli Wildlife Sanctuary is in Shimoga, and this landfill is of Shimoga City Corporation. This is in Karnataka. Why is this notification that we're talking about dangerous? It is dangerous because even with the existing regulations, we are already citing landfills inside wildlife sanctuary. With the notification, some of the protections and the safeguards would be removed. Then what would happen? So this is why we're considering this extremely dangerous. And EIA 2006, since it came into effect, it's almost been it's going to be 20 years next year. Lot of dilutions to the notification has happened. It has happened through amendments, office memorandums, and circulars. This is the latest. The 3rd October 2025 amendment to the EIA 2006 is the latest, and the latest dilutes the EIA 2006 notification by exempting landfills and waste to energy incinerators. This is pan-India, across India, from the requirement of prior environmental clearance. Environmental clearance is a process for preventing harm. It's a precautionary and preventative decision-making tool, which comes under the EIA 2006 notification. And the key operative word here is prior. It is a prior environmental clearance. This is not something that is done post the project has been established, but before the project has been established. Now, if you want to see the Gazette, this is the Mapping Malnad website, and you can find this article there when you go. So if you want to see the Gazette itself, you can click into this, and this is how the Gazette notification looks. It's in Hindi and English, and this notification has just come out on the 3rd of October 2025. And as constitutionally mandated, the citizens will have approximately 2 months to respond to this notification, and that 2 months expires December 12th. And by then, any issues, comments, objections, or you like the notification, you don't like the notification, you will have to write to MOEF. This is one way of exercising your democratic rights apart from voting. This presentation has two parts. Like I said, how the exemption itself was introduced in the draft notification. One is, like I said, many people in the water sector here and are very familiar with the concept of Karnataka State Pollution Control Boards, or as a matter of fact, any state pollution control boards procedures. That is consent to establish and consent to operate, or it can be consent for establishment and consent for operation. Consent for establishment is the permission that you take from Pollution Control Board when you want to start the construction of your industry. In this case, it's going to be the landfill and waste to energy facilities. Then consent to operate is after you finish your construction. It might take 2 years, 3 years, 5 years. After you finish your construction, you go back to Pollution Control Board and they give you something called as consent to operate or consent for operation. And this consent for operation will typically have, your effluent treatment plants, what are the standards for effluent treatment plants, then your air, under the Air Act, what are the emission standards for that. So these are all compliance mechanisms after the industry is established. Now, environmental clearance process comes even before all of this happens. That's the reason we term it as prior environmental clearance. The moment you synthesize a project or a landfill saying, I'm going to put this landfill in this location, the EIA notification 2006 kicks in and the environmental process kicks in. So this is a decision-making tool. CTO or CTE, the case PCB procedures are compliance tools. So the EC decides whether this project, based on scientific assessment, social assessment, environmental assessment, it decides whether this project can be sited in the said location. It identifies the impacts. If the impacts are unacceptable, then the project is discouraged in that location. If the impacts are acceptable, then there is mitigation measures. So once these things are figured out, then this information is put in the public domain in the form of public hearing, and the people get to know that such projects exist, are coming up in our neighborhood, and they get a chance to look at the impact assessment and voice their concerns. After they voice their concerns, if the community doesn't want that project in their backyard, then they have the right to seek justice. They can go to NGT and challenge the environmental clearance process within 60 days. So the EC and the CFE and CFO are not the same, as you can see from this explanation. However, the notification is equating the environmental clearance process with the pollution control board process. So the prevention and precautionary decision-making tool is not the same as compliance tool. So they're completely for different purposes. And this is the basic justification and a false justification that the notification is using to do away with the environmental clearance process. So what it basically does is it removes communities' basic right to information, democratic participation, as in the public hearing, community oversight. So if you don't know that the project is coming in and you're not able to identify what the impacts are, who the people are, who the actors are, and what sort of pollution is going to happen to the water, to the air, and you're not allowed inside the facility. So all of this also sort of removes community oversight and public accountability and access to justice just before the take shapes and before the pollution happens. Once the facility comes in, it's very hard afterwards, once the damage starts to happen. So this key word here is prior, precautionary, and preventative. And by equating that decision-making process of EC with CTO and CFO, the draft notification sort of justifies saying that we can remove the public hearing and the clearance process from the EIA 2006 notification, both for the landfills and also for waste-to-energy plants. This is one way, it's one justification. Another justification, and this is the most important one, and I'd like to explain that with this infographic here. So many of you might know, Pollution Control Board has a color category for grading the pollution index of each of these industries and their processes. Based on that pollution index, the consent mechanism, the inspection management, all of that happens based on that. So if based on their own calculation, if the pollution potential is greater than 80, it is considered as red, like your hazardous waste landfill. And we have ready bulk drugs and pharma, they're also red category, they're highly polluting. Then we have orange, whose pollution potential is less than 80. Then we have green, whose pollution potential is even lesser. Then we have white, which has no pollution potential at all. So this is used for merely administrative purposes by pollution control boards across the country. This is whatever I'm saying is sort of all across the country. Pan-India change. Now, very recently, early this year, Pollution Control Board, Central Pollution Control Board conceived something called as Essential Environmental Services. Essential Environmental Services, they define as facilities considered to control, reduce, and manage pollution generated from domestic and industrial activities, right? So, in that, there are two, industrial and domestic. In industrial, you have the common effluent treatment plants. It is not the effluent treatment plants within the industry itself, but several industries decide to take their effluents for treatment in a common effluent treatment plant. So hazardous waste landfills, then hazardous waste incinerators, and the biomedical waste incinerators, we all know about Maridi. So these are all considered as essential environmental services of industrial source. Now, the landfill, municipal solid waste landfill, waste to energy plants, the biomining projects, and refuse driven fuel, RDF it's called, all of these, and even the composting from solid waste, segregation units, these are all called as essential environmental services which are domestic in nature. right? For the ones that are domestic in nature, here, the second one, they are considering that as blue category. All these industrial activities of common effluent treatment plants, hazardous waste landfill are still red. They are highly polluting in nature. But the landfills and waste categories have been reduced to something called as a blue category, which is not based on pollution potential. Unlike red, orange, and green, blue is not based on pollution potential, but it is based on the false notion that landfills, waste to energy projects do not generate hazardous or infectious waste. So the essential environmental services of domestic source, that is the landfill and waste to energy projects, which are blue category, are considered as blue category because Pollution Control Board is saying they do not generate hazardous or infectious waste. And this is quite significant because we all, I think, generally understand that landfill and waste to energy plants and anything related to solid waste are indeed hazardous and indeed infectious. As can be seen here, the landfills produced heavy metals, they produced dioxins and furans and VOCs, same thing with WTE, waste to energy incinerators as well. So, and because these produce hazardous materials, hazardous leachate and hazardous emissions into air, they themselves are considered as hazardous, but for some reason, Central Pollution Control Board has considered that these facilities are not hazardous and does consider them as blue category. And you can see here, if I zoom in here, this is the list of sectors that are blue in category: municipal solid waste, landfill, waste to energy projects. Then you have the C&D waste processing plant, then you have sewage treatment plants of certain capacity as well. But the pollution potential has remained the same. As a matter of fact, you can see that waste to energy plant has 97. Its pollution potential is the same as coal-based thermal power plant. And you can see the hazardous waste landfill also has similar pollution potential. So despite having those pollution potential, now CPCB has considered them as green. So by falsely declaring these sectors as non-hazardous and blue is one justification for downgrading such sectors from not receiving EC. This is based on scientific falsehood. A scientific falsehood is now becoming a regulatory justification in the draft notification. And another point that again goes back to the same image here is what you can see here. In this, waste to energy plants usually they burn waste to generate energy. So they have, they can be 5 megawatt energy generation, 10, 12, 15. According to the EIA 2006 notification, if any waste to energy plants generate anywhere between greater than 15 megawatt of energy, then they need to get clearance. If it is less than 20, you get clearance at the state level. If it's more than 20, you get clearance at the central level. So, but they need to get clearance. But here, for waste to energy projects, they have not mentioned what the megawatt it is. So what it does is it allows the draft notification very clearly says that if the sectors are considered blue category, then they are being exempt from the EC. So which means that waste to energy plants, irrespective of their energy generation capacity, is now exempt from EC. So this is what the notification says without actually removing that particular section, EIA 2006 notification. Typically, when the amendments are done, the notification will very clearly say section 1D, we are omitting this word, we are omitting this sentence, we are omitting this line, or we're replacing this line with this. So they're very specific. That is how the amendment takes place. But in this notification, there is they have created what we call as a statutory loophole by actually not changing that particular section in the EIA 2006, but by merely mentioning blue category in the notification, giving an illusion that WTE plants does not need EC, but in fact, as per law, it does need EC. So what this does is, as a industry project proponent of waste to energy incinerator, can use this draft notification, bypass the EC and cite it and start construction. And the community activists would know about this much later, but by then the investment would have already happened, construction would have happened, and perhaps even operations would have started. At that point, when the citizens would want to seek judicial remedy saying due process has not been followed and you go to court, the court would say, yes, as per law, EIA 2006, this needs to be, EC needs to be obtained. But then, as per the notification, which has opened the doors for saying there is no EC, the confusion starts, right? And it places you in what is called as a fait accompli, because the investment has already been done and the operations had already been started. The court would be obliged to say, all right, let's do something called as a post facto environmental clearance. And people who are following the Supreme Court judgments, just a few days ago, the Supreme Court said post facto judgments, post facto environmental clearances are okay, right? So what this does is it allows the project proponent to bypass the safeguards that are set in place both for the environment and for the communities and proceed with the project with very less safeguards. Even with the safeguards that we have currently existing, we are citing the landfills in wildlife sanctuaries, and there is no leachate treatment plant. The leachate is directly released into the rivers and streams, and the air scrubbers are not there, and the dioxins and furans are directly released into the air. So the question, what we think this is happening is it's sort of a free license for the landfills and WTEs to pollute. So this is how sort of the law changes create the statutory loophole and create conflict between the citizens and the industry proponents and create confusion in court as well. So now, what are the consequences of this? Obviously, the landfills and WTE incinerators can now be cited anywhere, regardless. And many a times, public comment period is when we know something like this is coming out in our backyard, and without that knowledge, it would be too late for us. So citing is usually a problem. So that's the major drawback. Then the second one is, most importantly, it is imposed on communities without their consent or knowledge. And we all know how harmful the landfills are. And I'm not going to talk about WTEs because Chaitanyan is going to talk about them. And I just want to quickly draw your attention to the harm from the landfills itself. The type of air pollutants, the type of water pollutants, and most importantly from the leachate, or when the landfills itself catches fire, dioxins and furans are released. These are one of the dirtiest of chemicals. And this was part of Agent Orange that was used in Vietnam. The dioxins are so toxic that they can cross the placental barrier, and the toxicity can be passed on from the mother to the fetus. Not only that, after being born, from the breast milk, it concentrates in the breast milk and it is transferred to the child from the breast milk to the child. So talk about intergenerational equity here. And also the fact that the child is born pre-polluted. So these are some chilling facts for us as to why we need to really look at these issues and make sure that landfills and WTEs may be needed, may not be needed, but then how are they run? How efficiently are they run is something that's really of concern here. So, and in Bangalore, we're all very much aware of Mandur and issues with Mavalipuram landfill. And not only the landfill part, even I've been myself to Lingadhiranahalli waste processing plant and Kannahalli waste processing plant. And just outside the gate, you can't even stand for a few minutes. Such is the foul odor in the surrounding areas. Right, so there's quite a bit of citizen movement against landfill. The fact is, nobody wants them in their backyard. I think that's the fact that nobody wants in their backyard is the reason the government has made this contentious decision of not including that in the EC, because the moment they include that in the EC, then the public hearing also comes in. So the citizens don't want it, and the government considers very contentious projects and is unable to cite it. And so I think this is also one of the reasons why this notification is sort of coming out. And in terms of waste to energy plant, there is a lot of data in terms of the dioxins being released and the corresponding health impacts that Chaitanyan is going to talk about. And another thing is consequences. It creates harm with no remedy, relief or compensation for the citizens. So what this means is that once when they're building dams, the villages, the settlements, the people who are in the submergence area, they get some sort of a relief, some semblance of compensation exists. When there's land being acquired for road or for other public infrastructure facilities, some compensation is being given to people. But then for the communities which are living around the landfill, they are affected by the landfill, but then they don't receive any compensation. Their lives, their lifestyles, everything changed. They have to leave the neighborhood, the real estate values go down, and they have to, for decades, continually deal with the pollution, not only pollution of air and water, but also pollution of their body, which results in incredibly high hospital costs, treatment costs. And this one example of how this is unfolding, I think here is with the Okla plant. Since it came in, the citizens struggle in court, and while the citizens were struggling in court, then the plant expanded, and it's still operational despite the bad air quality. I even bad seems like a very harmless term for the kind of air quality that is quite now in Delhi. So this, once the damage starts happening, it's extremely hard to reverse that damage or stop that industry, or to get the industry to clean up and run the operations in an efficient manner, so it's not affecting the environment and people around. And yes, the communities are the most impacted, but then fundamentally the way the air travels, the water, and how it interacts with our bodies, it needs complex scientific analysis and data to kind of figure out, where are the cancer clusters happening because of this project. So there are far-reaching and irreversible damage of pollution both to the environment and human bodies, and they're discovered too late, and it's too late at that point to do anything. And the last one is, constitutionally guaranteed environmental protection. We have the Article 21, which gives us the right to clean water and air. Then we have the government has the duty to protect the environment, and so do we under Article 48A. And then government is a trustee of these natural resources, and are they protecting it? And then what about the precautionary principle? Precautionary principle has been repeatedly firmly established by the Supreme Court, right? So precautionary principle is where we anticipate and prevent environmental harm, and EIA is one of those tools that did that. And removing that EIA process and the public hearing process, is a direct assault on the constitutional rights. Then it sets a dangerous backdoor precedent, the way the notification is craftively written in terms of blue category to exclude all of them from EC, even though the actual law change has not been made. It creates a statutory loophole, creates confusion, allows such projects to move forward. And again, it shifts from prevention to post-damage cleanup. And I know in the discussion groups, we talk a lot about technology to clean up, which is good. We need that. But then what about the fact of that, there is prevention, there is mitigation, and our Water Act is primarily placed on prevention and mitigation. So some of these pollutants should not be in the environment, and they are. So, and many a times, most of the times, or majority of the times, cleanup is just not possible once it goes into the air and water. Bhopal gas tragedy, I think, is one of a classic example. The toxicity still persists in the soil and groundwater. The rivers, we work on rivers, and this is a Yamuna frothing. This is Vrishabhavati where the Bididi waste to energy plant is located. And this is Dakshina Pinakini. This is also the waste of Bangalore. And then this is Noel River. So is there a possibility for us to clean these rivers post-damage pollution? That's sort of what the EC does, is that it shifts from prevention to post-damage cleanup, which is very impossible. With that, I end this presentation saying December 2nd is when the time for citizens writing comments expires. So I urge the people who are here to write to MOEF asking them to stop this notification. And on the website here on top, you can go to the campaign page where you find all the details that's needed to write to MOEF. So with this, I end my presentation.